Today we have another guest who's going to be joining us on a serious matter within the judiciary. So last Monday, President Muhammadu Buhari swore in 67-year-old Justice Olukayode Ariwoola as the acting Chief Justice of Nigeria. Ariwoola takes over from the outgone Chief Justice of Nigeria, Justice Tanko Muhammad, and is expected to serve in an acting capacity till the further confirmation by the National Judicial Council. Joining us now on the show is the managing partner, Petchstone and Grace, LP Osaro Egbobamien. He's the Senior Advocate of Nigeria, SAN. Welcome to the show, sir.
Thank you very much. Thank you.
All right, so we need a bit of understanding because the recent resignation of the CJN opened up a whole lot of can of worms on what happened, especially because preceding that was a letter written by the Supreme Court justices, about 14 of them, complaining about their welfare, you know, and all the issues I've had concerning the justices. And then we know the CJN had responded and said, listen, we're not oblivious of the economic realities we're having. This is not having to do with me personally. It's the fact that this is our realities. And then weeks after, he resigns. What's going on? So in your view, do you think his resignation is connected to the right to the issues raised by the Supreme Court justices?
Thank you for having me. This is my second time here.
Yes.
First, let me say that when I came here the last time, I wasn't a member of the National Judicial Council, NJC.
Yes.
So I'm now a member. And therefore, in speaking to you, I'm speaking in my personal capacity. Okay. I'm not speaking as a member of the NJC, even though the invitation was on those grounds. There are systemic failures. I saw the letter, and I don't know if you read that letter. It's supposed to be a private letter. The very fact that the letter was leaked in itself reveals the level of decadence in the entire system. But you know, it's been happening for a while. If you read that letter carefully, the complaint was more in connection with the administration of the court system as opposed to the administration of justice. In other words, the allowances for the judges, the fact that training was a problem, fact of electricity, diesel. Yeah. And the topic I was asked to look into is what are the challenges and how will the present acting chief judge, if he's confirmed, most likely he probably will be, how will he deal with those challenges? So the first point to make, looking at that letter, is to distinguish between the administration of justice and the administration of the court system. In most other jurisdictions, the administration of the court system is domiciled with an independent body that liaises with the chief judge. And let me break chief justice. Let me break that down. Let me break it down. So the Chief Justice, and if I use a pedestrian analogy, the Chief Justice is involved in deciding, perhaps with the registrar, how much should be paid for stationery, for newspapers. First of all, he's not trained in that skill of administration. It's a complex issue to administer, and how do you prioritize what is important? If the roof of the Supreme Court were to be leaking, the justices of the Supreme Court say that our training has been affected and our allowances have been affected, how does he make a decision whether or not he should fix the roof of the Supreme Court as opposed to training? So, although this grievance was directed at the Chief Justice, it's a bit more serious than that. It's a systemic failure. It is not the Chief Justice that should be dealing with the administration of the courts. It's an independent body. The good point here is that we were involved in investigating many of these problems only recently. And a number of institutions came together for the first time. So you had a judicial summit that was held on the 17th of January of this year. That summit was organized by a combination of the Nigerian Bar Association, the NJC, which is very interesting, the JRI, Justice Reform Institute, and JRP, Justice Reform Project, the Conrad Arnold Foundation, as well as the last one was It will come shortly. But basically, these groups came together, and for the first time, you had the legislature, you had the judiciary, and then you also had the bar. And we all sat together, all those who were involved in actually making a difference, and all those who will be involved in reforms were all there together, and we agreed on what to do. So there were recommendations. 3 areas focused on. One was the selection, appointment, and promotion of judges. The other is budgeting and accounting. And the last one is the acceleration of justice, which is predicated on the earlier 2. Now, so what we need to do is clear. The issue is implementation. And when I say what we need to do is clear, it's not that that is new, it's not innovative. I think I always refer to Justice Waifo's valedictory speech in 2005, where he listed or he chronicled some of the defects in the judiciary, particularly the quality of judges that were coming into the Supreme Court. And he said it's only a matter of time. So you have a situation where Justice Waifo, and I'm speaking through Justice Waifo's document because I appear before judges, so I have to be careful and I can't generalize. But speaking through his documents, he said the quality of judges who were admitted into the magistracy was suspect, and it was clear that they were not up to standard. He said, but that was seeping into the superior courts of record, the high courts, the Court of Appeal, and God forbid the day where there's incompetence in the Supreme Court.
Wow.
This was in 2005, and many of the other justices, including Justice Mukhtar, had made these kind of comments in their valedictory speeches. The question is, what was done about it? There needed to be systemic reforms. Fortunately, we're at that stage. So I think the present acting chief judge has his work cut out for him. It's fortunate that these recommendations are predicated on empirical evidence. So the civil society that joined us went into great length. The UNODC, so that's trying to remember, went into great lengths conducting a research as to what should be done. And so what we're recommending now is predicated on this empirical evidence.
So when you started by explaining how we place management, like there are different areas. Management is different from being a judge. It's a totally different thing. It's something that Nima and I had discussed with the medical sector, how we give CMDs to doctors as opposed to people who truly understand management. And you already allude to the issues that and the resolutions that can come in as solutions. However, I feel that the way the previous CJN stepped out, it should have been made to address some issues. And it seemed because he's stepping out on health grounds, those issues will not get addressed. And if there's no closure, how do we successfully move on? If people have accused him of some things, and then suddenly he steps out of the scene, and then we expect the next person to come to be a messiah, are we not being unrealistic with our expectation of the new acting CJN?
So you're correct. If the new CJN comes in, he will find out that there are structural inhibitions. And he's probably going to make a few changes, which might not actually fundamentally address the problem. I think it's more than that. When I saw that the present CJN, the immediate past CJN was given an award by the president, I thought it was a bit hasty. I thought that what should be done was look into the situation and see what happened. But I want to go beyond that because, in truth, there are structural inhibitions. Certain things need to be changed. The way the NGC is constituted must change. The Chief Justice of Nigeria has 80% appointing discretion within the NGC. What that means is that whatever the Chief Judge does, a reflection of his personality is what the NGC stands for. And this permeates through the entire judiciary. That kind of
Nobody should have that kind of power.
Correct. So these are fundamental changes that have to take place. There has to be a distinction between the administration of justice and the administration of the court process. You cannot get the chief judge signing very pedestrian invoices, attending to invoices of that nature. That's what it looks like. If you read that letter is extremely revealing. Because what the letter said is, oh, we've gone to our leader. And the word used was our leader. I mean, that in itself permits a culture that is not good. It's not a leader, it's first among equals. So the other justices say, our leader is not doing the right thing. I agree. Choice of words. But of course, it tells you the culture that's permitted in. So what we're saying is that we must address some of these fundamental changes. Some of it doesn't require constitutional changes. You see, how do you become the Chief Justice of Nigeria? Once you are admitted or elevated to a superior court of record, you can be the Chief Judge, no matter how incompetent you are.
Wow.
That's the system that operates today because, I don't know if I should go into the detail how it works.
Let me go into a quick break. When we come back, we'll continue with this conversation. Stay with us, we'll be right back.
Stay tuned. Your View will be right back.
Thanks for staying with us. We still have our guest with us, Mr. Osaro Egbobame. Yes, the SAN. Yes, Mariam had a question for the break. Go ahead, please.
So, I know that many Nigerians are just waiting to hear. The former CJN, is he corrupt or is not corrupt? That letter that was written, does it in any way prove that there was corruption during his time or he was involved in any form of corrupt practices on one hand? On the other hand, is there a system that can charge him, that can prosecute him, that can investigate him? That's what Nigerians want to know.
All right, I'm tempted to answer your question in the reverse, whether there's a system that can investigate him. The factual question on whether or not he's corrupt, that is obviously a difficult question to answer in the absence of real empirical evidence. But when you're in the administration of justice, when you're sitting in the adjudicatory role, when you occupy such an exalted position, there's a way Justice Waifo talked about the need for persons who have any aura of corruption around them not to actually be admitted into the bench. Let me read what Justice Waifo says, which is revealing. This was in 2005. Let me just read what he said. He said, as regards the appointment to the Court of Appeal, names are submitted for consideration for appointment and eventually successful candidates emerge. It is not at all clear what verifiable criteria are used to ensure the suitability and capability of those appointed. But whenever any of those appointed prove indeed to be suitable and capable, it is rather a matter of good fortune or chance. In other words, whether or not they're appointed is a matter of good fortune or chance. It could thus happen that even those about whom there is a common knowledge of corruption pass through. Those with skewed appreciation of the legal principles and the lazy ones may similarly benefit. I think those responsible for such appointments have an uphill task because of the lack of sufficient data available to them. In my view, there are certain imperatives which must not be compromised or overlooked if a particular appointment can be truly justified.
So what are those?
The system of appointment has to be strengthened. We don't have an independent criteria of verifying whether or not somebody is suitable. You can't have the minimum standard as the only standard. So what happens today if you're 10 or 15 years, depending on whether you're going to be Court of Appeal or the High Court, 10, 12, or 15 years, that's the criteria, and you've practiced law. Now, even the practice of law, sometimes there's no verifiable criteria whether or not you've been in practice. Sometimes we see people sitting on a bench and they say they've been maybe at customs or in roles that doesn't demonstrate how they could have acquired practical experience for the sensitive role that they're about to perform. So what we've suggested, and I think the good news, and I think progress is being made, that particular summit came up with some recommendations, which has now been backed up by some empirical evidence, that there needs to be a standard. That standard will be superintended over by an independent body, maybe the National Judicial Institute, Convention on, there are a few others, civil society joined the group. We will simply be replicating what is happening in many other parts of the world. So if I sit at the NJC and I have documentation regarding a particular candidate, I can read that documentation against a verifiable standard and see whether or not that person, qualifies to be appointed. Today, there is no such standard that I know. Some states independently, and I think the Attorney General of Lagos State at that time, Yemi Oshibajo, had begun to introduce some sort of standards.
Right.
Nowhere in the world do you simply just become the superior court of record simply because you're connected or you're...
How did we get away with it for so long?
So all about the
Because
requirement
in the past it worked in the 60s and 70s, and that is because those who actually got there on merits. So they were more likely to recommend a system of meritocracy. Now, countries that actually acted in that fashion, including the United Kingdom, have moved away completely. But we're stuck there. And we're faced with more challenges. During the time of the 60s and 70s, what you had was a military institute.
Right. Yeah. Let me come to Nima. Nima, your thoughts?
there used to be, or there still is the major requirement of the most senior on the bench when it comes to the Supreme Court appointment. So you would not necessarily just be appointed by your connections. You had to be, the most senior. Does that requirement not, mean that you most merit that position at the time of appointment? Or have you ever seen in the past any appointment that, contradicts that to raise the question of corruption?
So most seniors should be a consideration only, not the only. And that's because you'll have in the bench some very bright people who've come in very early. I give an example of Lord Sumption in the United Kingdom, who went straight from the bar to the bench. He spent 7 years there and made remarkable impacts on in policy decision-making. So you can't, in a position that is so sensitive, rely only on the fact as the most senior, particularly because the criteria...
Maybe at the point of appointment.
Yes, particularly at in a situation where there is no standard to appoint. So what it means is anybody who gets into the system can travel straight to be the Chief Justice of Nigeria. There must be a standard such that, first of all, not every lawyer is qualified in that sense to be a judge, a sitting judge, and not every judge is qualified to go to the Court of Appeal. It can't be for every judge.
I agree.
Everywhere in the world. So we did a comparative analysis. Kenya, Ghana, United Kingdom, South Africa, all these other jurisdictions have had similar problems like ours, but they've moved on. So you see, I referred to Justice Wifo in 2005, made recommendations. All the recommendations we're talking about are not new. But I think for the very first time, we've come to a situation where all those who are necessary for the change to happen came together and said, these are the recommendations. And all we need to do now with the new acting Chief Justice is really to...
Let me come to an issue that the former Chief Judge raised. He said that, listen, budgetary allocations is at the point where you allocate the budget doesn't mean I get the money. It's one thing to have a budget to sort out welfare. It's a whole other ballgame to actually have the money given to you to do the job. And then, according to him also, there are other priority areas, which is what you're saying, that fixing the roof infrastructure versus issues of welfare. And you've also said that they need to get an independent body. But my worry is, how does the judiciary self-regulate itself? What measures can they take to actually ensure that the self-regulating approach they are taking is the right one? Or should we have an external way of looking outward in to see how they can help them resolve this issue? Because if judiciary collapses, it's total anarchy, just like Dr. said earlier.
If it collapses?
As
So those are two questions in one. Yeah.
And, you've asked a number of questions. So let me try and break it down and deal with each one. So the first thing is budgeting and accounting. Again, we're fortunate that we have an in-depth analysis into this, and there was an outcome and a recommendation. So one of the things that has troubled many of the stakeholders in the system is this question of the independence of the judiciary as far as revenue is concerned. What you don't want is, which happens today, a chief judge going to a governor sitting in his office and pleading to get his allocation. So I think it is important. And governors use that, unfortunately, to manipulate the system. So many of us were quiet when there was just agitation, or we were supporting it implicitly. But you see, it's one thing to ask for independence. It's another thing to be responsible and be accountable about what you're giving. So there are two things. But we decided to focus on the independence first, and then we go to the next stage, which is self-accounting. So when we had all the stakeholders come together, the executive said, okay, you may be right that what is being allocated is insufficient, but let us see how you spend what you're given in any case. Make your books open, and the judiciary refuses to do that. So you have that problem which is now being resolved. That's why I say the acting Chief Justice of Nigeria really doesn't have too many problems to deal with. The problems have been identified. It's now a question of the will.
Yeah,
yes.
the will to do it.
So that is why we say, okay, judiciary, this is a point they're making. Nobody is giving money and is asked not to account. And you want more money, you must tell us how you expend that money. So at that level, it's being dealt with as we speak, and I'm hoping that the new CJN will look into this. So that's the first point.
I'll let you answer the second question after the break.
Okay.
Stay with us. We'll be right back.
Stay tuned. Your View will be right back.
Thanks for staying with us. We still have our guests with us. And for the break, you were answering the question I asked earlier. The second part of the question.
Yes. The second part of the question was really, for me, or the way I put the question is, what can be done about this?
The breakdown of...
The breakdown. You use the word, very strong words, as the system is likely to break down. And I say it's broken. And we now need to fix it. I'm optimistic that we can fix it. And I did say, one of the recommendations which can be implemented immediately that will resolve these problems is for the CJN to simply start demarcating the administration of the court system from the administration of justice. Now, the brother justices in that letter is revealing, complained about their welfare. Their welfare, their individual welfare, a substantial part of it. So if the CJN had dealt with their welfare, then what happens to the other administration of the court system in case he's not dealing with it? Who complains? Because the system is opaque. Who is going to be the protector of the general public that use the system? So today what has happened is confidence is eroded. Whether you're a plaintiff or a defendant, prosecution or a defendant, anyone who comes into or in contact with the administration of justice goes there seriously scathed. And when you come out of it, you regret ever going there. Those who benefit from the system are those who know how to take advantage of the system, which is broken.
Yeah,
So,
the major issue now.
Yes.
The leaked memo was signed by 14 justices. Top of them is the present acting CJN. And if we're looking at, whoever heads the justice system to fix this problem, how do we then, get someone who thought at the time of that memo that the only issue is that we are not being taken care of?
That's why I say that I'm extremely optimistic that change will come. Because he was part of a system that affected him negatively and affected the entire value chain, the administration of justice. Listen to what I said. Affected him and affected the system. He is now under an obligation to fix the whole thing. But he doesn't have much to do because a lot of the work has been done and we simply just produce it to him and then he goes...
We hope he does. Okay, so let me take this call from Joseph. Joseph from Bonny Island. Good morning. Are you there? Hello, Joseph.
Going back to my question about judiciary, I feel that judiciary is so important that people many people on the street don't understand why they are angry. And one of the reasons we're angry is because people feel like there's no justice. People can do things and they will get away with it. So I'm not going to wait to let the judiciary or the court system release him or the case be pending in perpetuity. I will sort this thing myself. And so they take laws into their hands just to exert that justice by themselves. And I listen to you and I'm thinking maybe there is hope. But how can the layman watching this show now feel like there is hope for him or her in this current justice system?
Very good. And I think what you've just done is to situate the importance of the rule of law in our society. Law is not just about the rules that regulate disputes. It is the values upon which the society is predicated. So if you're even in a queue, the reason why you cannot successfully jump the queue in other jurisdictions is that if someone stops you and it degenerates into a fracas, there's a system that will resolve that problem. Today in Nigeria, unfortunately, it doesn't appear as if there's a system. And that system that exists, the whoever is going before it doesn't have confidence in the system. You need a level of confidence for the administration of justice to be effective. So the man on the street is lacking in that confidence. So, I mean, I'm talking with empirical evidence. Most people have no confidence in it. Now, there's a responsibility of those of us who just joined the NJC to perhaps bring this to the knowledge of the judges who are insulated from many of these things. To say, look, it's not just about the welfare of the judges that's an issue here. It is the entire administration of justice that is in crisis. So it has to be dealt with from that perspective. So I'm pleased that the acting CJN was part of that problem. You signed that letter. And I think everybody should read that letter. That's a scathing indictment with the greatest respect. And I'm sure it wasn't ever meant for the public on the immediate past Chief Justice of Nigeria.
Sir, let me pick your brain a bit, because I've always had this mindset, and this is not regarding this issue. What you said recently just reminded me. I've always had a thinking that we're in this quest for the rule of law, we're way ahead of the real value system that we have in this country. So we have the rule of law, which is great, but where we are as a people, we are at a point where people need to be hanged. We're at a point where people need to be killed for raping children. We're at a point where we need to let out, like, we're not as advanced as the Western world, where they can reason and say, you know what, well, she killed him because this is premeditated. We're not there. You killed him, you die. So do you think we need to take a few steps back in our exerting of the rule of law and what really connects to the Nigerian people? Because we are in a chaotic state. There are people right now in this country that totally do not understand that there's something called rule of law. Okay. So do you think we're going way too fast, or we need to take a step back, or we can still get the Nigerian people to catch up? Because I always make that argument with Nima. Nima says, Morel, we must never water down the rule of law because it's important. But there's some cases we hear, we're thinking, come on.
Because the process of the rule of law is not working. There are too many people who are occupying sensitive positions that have no business in that occupancy. So there is also the question about law being the culture, or at the very least, it's a mirror of our culture. So those who are actually being elevated to the Superior Court of Record, who should set the standard, if they're not setting those standards, there are certain ethics and nuances that actually follow the rule of law. So in Nigeria, to demonstrate that you're a big man, you broke the law, and there are no consequences. And then you expect that the young man or the man on the streets, the youths, should actually obey the rule of law. So the rule of law is so important. There's empirical evidence to demonstrate that countries that do very well economically tend to be obedient to the rule of law. So in Nigeria, I think that just ethics, what is necessary to actually ensure that you have an effective rule of law, is absent. And that is why you can have people who are not qualified. In every society, you have people who will not obey the law. So the law is made for them. They are not made to occupy the seat of the law, to start enforcing and to start adjudicating. That's the problem. So our system needs to be strengthened so that we can achieve that.
Okay, so having said all this, I always come to the fact that, you know, we have complained and complained. What can I do as an individual Nigerian to see a difference?
So every practicing lawyer, I always start from there and then we go to the citizen, has to know the law, has to know what is wrong with the law, has to be able to predict change and participate in that change. What we do in the administration of justice and why we do it must be called into review consistently so that we're changing our rules and our processes as we go on. Unfortunately, you now have a pool of lawyers who perhaps don't understand that responsibility. And from that pool, they become judges. And from those judges of the Superior Court of Record at the High Courts, they travel to the Supreme Court. So the reason why I say I'm excited, when Olukayode, the president of the NBA, submitted my name, he never told me. Maybe I probably wouldn't have accepted, saying that I didn't want to get involved. But I've accepted the position with enthusiasm and passion, and hoping that if there's anything that I could do, which is reforms, I'm now in a subcommittee dealing with selection appointment and promotion of judges. So what can you do as editors? We must denounce practices that break the law. We're too quick to give credit to people who circumvent the rule of law. So even in politics, it's the same thing. If you look at how we're playing our politics, and these politicians, we end up appointing our judges, we see the correlation there. So if you see that those values are less than what you expect, they are likely to appoint judges who will play to their dictates. So we must try and get a system that is strengthened, and then you can't introduce politics into it. And we've done all the work. I mean, you know, civil society, all the work has been done. So I'm hoping that the present acting Chief Justice, and you know, once we have an interaction with him, he will implement.
So is the judiciary really independent? Because we have that four arms of government, the executive, and you're thinking to yourself, okay, because your money comes from the executive, it's so difficult. So what can we do to make the judiciary truthfully completely independent of every arm of government?
So there are a combination of things. You're right. If you are beholden particularly to your revenue to administer the court to a particular governor, you may be an institution where you are suppressed or where there's oppression and there's influences. But if you have a sufficient level of character, law is not just an application of skill and art. It's also an application of scholarship as it relates to your work, academic work, and your character. So if you have strong characters in the bench, it's going to be very difficult to influence them. Let me give you a story that my uncle, my late uncle, shared with me. He was Justice in the Supreme Court, Justice Obaseki. They were sitting once, and I think it was Gawan who was the head of state. And Gawan had sent a note to the Chief Justice of Nigeria at that point. And the Chief Justice asking that he'd like to see him. A very cordial note. And the Chief Justice turned it around, turned the paper around. I'm the head of a system, and I am sitting, I'm sorry, I can't see you. Now that takes character, spirit of excellence, to tell the Supreme Court, you can't just call me now. But these days, I mean, you see what happens. So, if the person who's been appointed, the appointing system is very important. If he believes that his appointment was as a result of the head of state, rather than his merits on the job, if the head of state calls him, he will jump. So the system of appointment, especially to the bench, is critical. There must be a systemic change. It's not about one person. Today, how do you get to the bench? It depends on who you know. Once you satisfy the very basic criteria, in other words, you've been 10 years. So if you've been mixing cement somewhere and you know great politicians, put your name through and you get through.
I think Nigerians want to be involved in deciding who gets there.
So the question really is that you get good judges by accident now. You know, yes, there are some many good judges.
We have accident.
And indeed, what happens is that those good judges are dispirited because they're in a system where their work and their sterling qualities and scholarship is not taken into account.
I mean, thank you so much.
Thank you so much.
We need to bring it back because I was reading one of these, those things that the judges, the rulings.
Newsletter.
What was
The
it?
rulings, yeah.
The rulings, and it's so watered down. You know, there was a time when I was growing up that my dad would give you one of those just to read, to understand. And you feel it's very, very interesting to read. But today, it's very watered down. You think even you can write this now.
Wow.
So it's really, really, I hear what you're saying. Times have changed, but we have to run.
Please, they need a refresher's course.
It's even more frustrating for lawyers who tend to be in-depth with their work, appearing before.
Yeah.
I can imagine.
But having said all that,
we have to run, sir. I do apologize.
having said all that, I'm extremely optimistic. You join us in the reform in administration of justice. And I'm running 42 kilometers in March.
Oh, yes, it's true. You run.
It's a marathon.
Yeah. Marathon.
We will make it. We'll
Oh, fantastic. Okay, that's all we can take on this. When we come back, we show the Who Wants to Be a Millionaire. Stay with us. We'll be right back.